All right, guys. Well, let's go ahead and get started. It's Saturday morning, August the 4th, August 4th, about 9:07 a.m. We're going to go ahead and get started. Got Sophia here in the office with me in the conference room in DFW. And this morning, we're going to talk about contracts and do a quick training session on contracts. Right now, you should be looking at the video screen. You should have up there our contracts training PowerPoint presentation. I will upload this. It has been updated a little bit since we did get new contracts in February. But if we take a look real quick, contracts. First thing we got to be careful with contracts. We must be scrupulous, diligent, thorough, extremely attentive to details. If you go back and look at our definition of what TREC's purpose in life is and their goal in life is, basically it is to protect the public from unscrupulous brokers. That means that we're supposed to be scrupulous. So anyway, guys, make sure that you understand this definition. We must be diligent, we must be thorough, extremely attentive to details, especially when it comes to our contracts. We want to avoid any issues. We want to write a good, solid contract that the title company and lender, everybody understands and can simply work on very, very quickly. If we go to the next part of it, we're going to be writing offers. What we're looking for from the other party is acceptance. Sometimes we get rejection. Sometimes we get rejection with a new offer. That's basically a counter offer. The other thing that we've got to do, guys, is make sure that you are making delivery, also known as notification. Doesn't do you any good to get an accepted contract and then not to sell a copy or send a copy to the other party. And also, this is a complaint that I see from buyers, especially sometimes with sellers. When they're complaining or they've got a problem, it seems like they always tell me that they never got a copy of their contract. Best thing that you can do, guys, deliver by email. You've got a paper trail, you can then prove when they got it, and you really want to make sure you get copies out immediately to people of anything that they have signed. So that is what's going on with delivery. Make sure you're communicating acceptance to that other party. The other thing that we've got to note, verbal is not binding in Texas. You're looking here at the Licensing Act, and basically this says unless there is a written agreement by the other party to pay a commission, we cannot go after them and try to enforce the collection of that commission. This is really talking about buyer rep agreements and listing agreements, but it is an important part of our business. So just make sure that you're doing things in writing. The next part of it, intermediary, we'll talk about this when we get to the last page of the sales contract, but we do need to define intermediary. People need to start off by signing that IABS form, information about brokerage services. So anyway, just a little bit of a reminder there on how we're working with the client. And then again, code of ethics goes a little bit further. It's just good business to reduce everything to writing, guys. I like to joke, or my phrase has always been, we're on our way to getting paid when people sign stuff. So we've got to make sure that people are signing stuff. We go in, guys. I'm being fairly lenient, I believe. We're asking everybody to turn in contracts within 7 days of contract execution. We will review the contracts, guys. We do have a specific email address. You can see it on the screen. It is contracts@texaswiry.com. So any contracts that you have, if you're doing a request for a commission disbursement authorization, email everything in to contracts@texasyre.com. This is where my assistant is checking every day, verifying what contracts are coming in, what CDAs are coming in, and constantly monitoring this email address. You can send them to me as well. I'd be more than glad to receive them, but please know that they are being paid attention to at contracts@texasyre.com. And our administrator, my assistant, is reviewing those there. So very important. Send them in, and send them in within 7 days. Your commission disbursements, guys, request that about 3 days before closing. Whenever your clients are getting their closing disclosure, make sure you request payment, that commission disbursement authorization. That basically is going to let the title company pay you at the closing table. So please be sure to note that address, and I'll make sure I put a posting on Facebook and send out an email on that as well. Next thing we've got, guys, is let's take a look here. Today, all we're going to focus on, guys, is the 1 to 4 family resale contract. So that is what we're going to be reviewing. What I'll do first is I'm going to go through some PowerPoint slides and go through the contract paragraph by paragraph. And then we'll go in and we'll actually look at a sales contract. And so anyway, let's go through that. We'll get started right now. And basically, you've been out, you've been showing. Finally, your buyer's ready to rock and roll. Time to write up the offer. So we get into that, and please remember, every contract has 2 sides. You've got the seller side, you've got the buyer side. We'll look at both sides of the equation, whether you're a listing agent or a buyer's agent. We'll look at the contract from both perspectives, okay? And really what we want to do is we want to learn how to fill out the contract. Earlier this morning, I did put a contract packet on our Facebook page. And basically that's everything, all of the addenda you need. And some of them you may not need. They may not pertain to you or your transaction, but we do have a contract packet. What I'll do today is I will fill out a contract and I'll put some completed contracts on the Facebook page. That way you've got some sample contracts. The other thing I encourage you to do, write some contracts on your own. Sell your dog the house, just pick a listing and practice before you actually get in front of a client, okay? The other thing is we are allowed to fill in blanks, but we are not an attorney. So we've got to be a little bit careful with that. Let's take a look at the different paragraphs in the contract. Number 1, guys, is the parties, okay? We want the full names of the seller and the buyer. They give us the names. I typically ask people for their driver's license name, okay? And we do need the seller, if it's a husband and wife, we do need both of them to autograph the contract because both of them are going to have to autograph the closing documents because of community property rights. So anyway, if you guys have any questions on that, do not call me. I'm not an attorney. Call the title company that you're working with, and they can give you some guidance on the specific transaction that you might be working on. So that's pretty straightforward. You know what? Let me go back to parties. Every now and then, guys, you will do an estate sale. So somebody passed away, they've probated the will. Maybe they've got a son or daughter or relative that's the executor of the estate. And I always get the question, whose name do we put in there as the seller? Well, it will be the estate of John Smith, the estate of Mary Smith, okay? And again, you will need to talk to your seller. Any documentation that they've got going, probate, all of those kinds of things, guys, make sure, again, that you're running all of that by the title company, and they can do a quickie title search for you and let you know exactly what's going on there. So anyway, just a little bit of prep work that you do on the listing side. It will affect the contract, obviously, but typically you're putting in there the estate of John Smith. On the signature page, you will put on there executor John Smith Jr. Maybe John Smith Jr. was the one that was appointed as executor, so that's what you've got going on there. So paragraph 2, Property. What are we looking at here? Well, we're going to need a legal description. Typically, we are getting this. Pardon me, I hit my kept hitting the key there. Typically, we are getting the legal description, guys, from the MLS. You can also get it from Central Appraisal District, okay? And we must have a good legal description. Obviously, most of what we're doing is in the city. It'll be lot and block. It's pretty straightforward. If it's a weird deal out in the country, out in a rural area, you may have a meets and bounds. Those are pretty long. We're probably going to put see attached and make it a part of the contract. So anyway, that should be pretty straightforward. Improvements. Take a look at the different items that are in there. And if there's something that the seller is not going to include in the transaction, make sure that it is going to be taken care of in exclusions, which is paragraph D. We highly recommend that if a seller is going to keep something, get rid of it before you put it on the market. Take it off the property, okay? And so anyway, and then again, if there are items that are going to convey that are not part of the improvements, not part of the accessories that we'll look at right now, then make sure that you're using the non-realty items addendum. Maybe they're leaving patio furniture. Maybe it's a nice grill in the backyard that is not permanently attached. And the other thing I would tell you, if you look at that form, it does ask you for serial numbers and model numbers. I recommend taking pictures of both of those. That way we've all got a paper trail of what's going on. Make sure you're jotting those numbers down on the non-realty item addendum. We did have a couple of years back, someone said the refrigerator conveys, and they left the ugly refrigerator in the garage and took the nice refrigerator in the kitchen. So anyway, be aware of that. Next thing you've got accessories, mailbox keys, different things of that nature. Sometimes we get into the solar panels. So that can be a debate sometimes. That's we should probably do a whole class on that. Anyway, exclusions. What is the seller keeping? And please be aware, you can have something excluded in the listing agreement. You can have something excluded in the MLS. If you forget to exclude it in the contract, it stays because the contract is the actual agreement between the buyer and the seller. So again, be scrupulous. Pay attention to detail. Don't get in a rush. I know sometimes we get busy and we overlook some of those things. But anyway, take a look at that. The next part, guys, obviously, A plus B equals C. Okay? So if it's a conventional loan with 10% down, that 10% amount would go under A. B would be our loan amount. That'll be the 90%. And of course, our sales price would be 100%. So don't forget, A and B equals C. B is the amount that we will be putting into our third-party finance addendum. So be aware of that. And pretty straightforward. You don't have to worry about adding in PMIs and MIPs and any other goofy fees. Just do the normal deal there. Number 4, this is if you're related to any of the parties in the transaction or you're involved in the transaction. You would need to put a statement in there that says listing agent is related to is son of the seller. Okay, listing agent is owner of the property. Okay, owner of the property is a licensed agent in the great state of Texas. Things of that nature. Got questions on that, guys? Reach out to me. Paragraph 5, earnest money. Now you'll note on the slide I put 1%. This is true typically in DFW right now because it is such a hot market. We're seeing closer to 2% just to make sure that your offer gets accepted. It must be deposited within 3 days after executing the contract. Now, the good news is that is business days. So if you wrote a contract on Thursday, Friday's the first day, Saturday is the second day, Sunday's the third day. Well, the title company is closed on Sunday, so you've got till 5 p.m. on Monday to get that done. Time is of the essence. The other thing that's going on, guys, don't forget, is if the earnest money is not deposited, The seller may now terminate the contract as long as the buyer has not deposited the money yet. So listing agents, watch that very closely. Make sure you're in contact with your title companies. Buyer's agents, move your behind and get that money down there. Okay. And then, of course, we've got the title company and their address in paragraph 5. And if there's additional earnest money required, we may use that. Typically, we don't see that a whole lot. If no additional monies are needed, just put a 0 in there and we'll be fine. Some of you guys are very, very good at contracts, and even if you don't use a blank, you put an NA in there. That is super duper thing to do. Maybe not all of us do that. I know I'm not quite that analytical, but nothing wrong with doing that if you want to do, okay? If you want to do that. Paragraph 6, guys, title policy and survey. It is negotiable who pays for it, okay? I'm still seeing the majority of the time the seller paying for it. Just an idea, if you're in a multiple offer situation, get the buyer to pay for it. It nets the seller more money without raising the sales price and bringing appraisal issues into concern. So anyway, take a look at that when you're looking at the sales agreement, guys. Again, RESPA rules say basically at the bottom, whoever's paying for the title company or title policy gets to pick the title company. So just kind of keep that rule or that thought in mind, and you'll be fine with your title policies. And the other thing we've got is the survey. Okay, this is talking about the title policy here. Make sure we've got the same title company name from paragraph 5 in here. Paragraph 6B, the title commitment. Basically, they've got 20 days to deliver it, guys. There is a 15-day additional time, I should say, or extension if there's some conditions that need to be taken care of. And the main thing I'll tell you about the title commitment, it's got 4 schedules on it. Read Schedule C. C stands for clear. These are items that need to be cleared up. Any problems that need to be clear, Schedule C, clear. Make sure you read that. If you've got questions, I'd be more than glad to take a look at it. Get with your title officer as well, and we can figure out what's going on there. The survey, guys, you've got 3 choices. If we're using an existing survey, that's going to be choice number 1. It must be acceptable to the buyer's lender and to the title company. So those 2 folks have to bless it. If it's good, we move on down the road. There are a few lending companies out there. I think there's a credit union in El Paso that does not allow you to use existing surveys. They're kind of the exception, not the rule. You can use them, and you do need the T47 affidavit there, signed, notarized by the seller. Get that done as soon as possible after you get the listing. Or your other choices, buyer pays for a new one, seller pays for a new one. So you've got 3 options there on a survey. I'm going to go on record and tell you every transaction we do, even if it's cash, requires a survey. If someone doesn't want to get a survey in the transaction, run, please. Don't walk to my office. Find me, okay? Get me on the phone real quick, because that's not that. There's 2 lawsuits I've been involved in the 20-some years of real estate, and they both included surveys. So please communicate with me on that. Paragraph 6D, objections. This is the area, guys, where anything that we need to check off. We'll look at paragraph 6A8 in a couple of minutes. There's, I think, 5 or 6 exceptions in that paragraph. If you want to buy survey insurance, there's only 1 exception. So that survey insurance is fairly inexpensive. It's only 5% of the title policy. Might be a good thing for a buyer to consider, is to check that off. But we'll look at that when we look at the contract. It'll make a little bit more sense, I believe. Paragraph 6, guys, there's 7 notices that they mention to you. Okay, number 1, get a title policy. They'll talk about POA, statutory tax districts. The markets we serve, we don't have to worry about tidewaters. If you're in Corpus, you're in Galveston, you may get into that. They talk about land being annexed. If it's within 5 miles of the city limits, it may become part of the city. And they talk about rural areas, unimproved land, special utility districts, public improvement districts collect taxes in some neighborhoods. So they're just notifying you this might be a possibility. Paragraph 7, probably one of the most important paragraphs that we're going to fuss with. This talks about repairs. It talks about who turns on the utilities, how long they leave on the utilities. It talks about our seller disclosure, and this is critical. If we're not careful, we can end up with a free option period. We'll look at that when we get to that paragraph. Lead-based paint disclosure is in here. And please be aware, guys, when we look at paragraph 7D, that we'll also note that it is an as-is contract. But the contract does state that this does not preclude you. Now, what does the word preclude mean? Does not prevent, does not stop you from having inspections done, negotiating repairs, and even terminating the contract, Mr. and Mrs. Buyer, if you don't like what they found and if they won't do repairs, if you do an option period. So they refer to paragraph 23, and we'll look at that when we look at the contract. Again, this is a very, very important contract paragraph, in my opinion. Lender required repairs, basically sale or no sale. If they don't take care of what the appraiser finds that needs to be repaired, guys, you're not going to have a closing because there's not going to be a loan. Buyer would get their earnest money back. Okay. And then finally, completion of repairs. And who's picking contractors? And we are supposed to have folks that are licensed, bonded, and able to do the type of repairs that are required. I joke about Chato, the handyman. He might not be a qualified repair person. But anyway, keep that thought in mind. We'll look at that. Property condition is going to be critical. Paragraph 8, guys. I'm sorry, I'm still in paragraph 7. Environmental matters. We do have an addendum for that. If you want to purchase a home warranty, a residential service contract, if you fill in the amount that's in the contract, that's what the seller will pay. Be aware, a buyer can pay. Okay, so it's negotiable who pays for it. And we'll look at that in the agreement in just a minute. Paragraph 8, here's where it talks about the other agreements, okay? We're not parties to the contract, but the way we get paid is in a separate written agreement. That's going to be our buyer rep. That's going to be our listing agreement. So we'll talk about that again when we get into the sales agreement. The closing date, guys, basically this sets the last day that the closing is supposed to occur because the contract does state on or before. It talks about getting the general warranty deed from the seller. We're going to bring good funds. Everybody is going to sign on the contract. And the other thing it says is all liens will be satisfied from the sales proceeds. So that's what you've got going on there. Paragraph 10, possession. This is the date ownership is transferred. Okay. Not necessarily the date that people are moving out or that the buyer is moving in. Seller gives up possession, buyer takes it over. Is it upon funding? Okay, you might use a lease there. We'll take a look at that in just a couple of minutes. Paragraph 11, be careful. Don't play attorney here. Avoid practicing law without a license. Again, make sure you're using the proper addenda. Be careful what you write in paragraph 11. Okay, don't get into complex legal provisions is basically what we need to remember. The other thing you're looking at, guys, paragraph 12, who's paying for what? The one thing I would tell you is when you look at paragraph 12A1B, this is where your seller is helping pay a buyer's closing cost. So please be aware, if you're in a competitive environment, you're probably not going to get a lot of help with closing costs because that comes right off of the seller's net. So let's say that you made a $150,000 offer. You asked for $3,000 in closing cost. Well, that $150,000 minus the $3,000 that the seller's going to pay for closing cost, it really sold for $147,000. So that's something we need to keep in mind. El Paso, not quite as competitive a market maybe as DFW right now, which is actually good news for a lot of us involved in the market. But typically there we can seem to get some help with closing costs. So anyway, especially if you've got some of the lower priced properties, you're going to need to help those folks with closing costs typically. Anyway, so we'll take a look at that. Prorations, guys, basically you pay for it when you own it. I pay for it when I own it. Taxes is the big proration. And again, typically taxes are paid at the end of the year. They're paid in arrears. So buyer is going to be credited a dollar amount from beginning of year to closing. Seller is going to pay. So they will be, I'm sorry, yeah, seller is debited, buyer is credited. I think I said that wrong earlier. Seller is debited, buyer is credited from beginning of the year through closing, and then the buyer is responsible through the end of the year. So you get that covered. Anyway, let's take a look. We'll go down, paragraph 14, casualty loss. What happens if the property gets destroyed? Got a property under contract, it burns down. Seller bears the risk of the loss. So be aware of that. Hopefully they've got some insurance and things of that nature. So just be aware of paragraph 14, default. What happens? This is when you're in breach of contract. The buyer doesn't perform. The seller doesn't perform. Or maybe a buyer wants out of a contract. We're out of option. We're out of the financing contingency, whatever it might be. Hey, Enrique, good morning. Whatever it might be. So you've got the default paragraph, guys, basically says three things. Number one, either party gets the earnest money and you're done. That's liquidated damages. Or someone can sue for specific performance. Now, what specific performance? I'm going to make you do what you said you were going to do. Okay? And I'm going to sue you for damages as well. So anyway, if we get into this point, guys, holler at me. I'm sure we'll be discussing some things and talking about that. Next paragraph, mediation. Let's mediate, not litigate. We're looking for a win-win solution is what we're looking for. So anyway, this is a part of the contract. It does state in this paragraph that if you want to, you can still sue. But the state really wants us to mediate first. So be aware of that, okay? Attorney's fees, loser pays. So if you end up in court, you sue another party, not only do they lose a judgment, the other thing that will happen is they would have to pay you your legal fees and they would have to pay you any filing fees for court. So be aware that is paragraph 17, okay? Paragraph 18, yes, sir. Oh, yeah, go ahead and close it. Thank you. Paragraph 18, escrow paragraph, guys, and what are we looking at here? The title company is not a part of the contract. The other part of it is this, they are not responsible for making people perform. So that is not something they do. They make no interest on the earnest money. And if the bank fails, sorry, they're not responsible if your earnest money was in that bank. That's actually in the agreement, okay? And again, they are not a party to the contract. Neither are we. It's the buyers and the sellers that are a party to the contract. Paragraph 18B, expenses, okay? What happens with the earnest money? Well, if the contract closes, you use the money for down payment, closing costs, etc. If there's an overage, they'll give that money back, okay? Now, the other part of it, what happens if it doesn't close? And we had this happen recently. Had a little deal, $500 earnest money. They'd ordered the survey. They had actually paid a closing company to go out and close. So they had spent, out of $500, they'd spent $451. So they paid those expenses, and I think they gave the seller in that example $59 and some odd cents because that's all the money that was left. Anyway, so be aware of that in paragraph 18. The demand paragraph, guys, basically, both parties have to sign the release. All parties have to sign the release. And if mutual release is not obtained, the party who's requesting the money can do a written demand. And the title company, if they don't hear a response from the other party, may decide to give the party that's demanding the money. So be aware of that. Paragraph 18D, damages. If somebody wrongfully refuses to sign an earnest money letter, your buyer terminates contract, they're well within the option period. Now the seller gets mad and doesn't want to sign. What happens? Uh-oh. He just gets mad. He don't want to sign it. On the 8th day, they're supposed to sign within 7 days. On the 8th day, the buyer sends them an assigram saying, hey, here's what it says in the contract. I don't want to have to go after you for damages. And typically the money, the release then shows up. But people forget this is in paragraph 18D. So that's to protect either party if someone else wrongfully refuses to sign the earnest money agreement. 18E, guys, basically notices are effective when they're sent to the email address and information that you put in paragraph 21. So be aware of that. That's what that's talking about. 19, all promises survive closing. All representations survive closings. Okay. Anyway, be aware that this is in there, guys. Sometimes people close. They think they got one over on everybody, and that's not exactly true. All promises survive closing. So if there's issues that pop up, you could still have some things pop up after closing. FIRPTA. Ooh, here's a good one. We just had a deal not too long ago that bombed because of FIRPTA. And this is actually something that's disclosed on the seller disclosure notice. When you take a listing, find out if the people are foreign nationals or not. And it's actually on the seller disclosure notice now. But anyway, because what happens, and I probably need to update this slide, IRS isn't requiring 10% anymore. They're requiring 15%. Okay? And so that money's held back. IRS gets hold of it, and typically your seller will have to file paperwork to get that money back. So anyway, 300,000 or less, they sometimes will not hold that back. Title companies are getting very, very strict with that. So there is a non-foreign affidavit stating that they are not a foreign person. The tough part on this, guys, is if the seller doesn't pay the tax, the buyer's responsible for it. So buyers get nervous when it's a FIRPTA transaction, as they probably well should. But anyway, we'll talk to our title companies about that. 21, guys, please do not put your information in this paragraph. This is the paragraph that talks about the buyer's email, buyer's address, buyer's phone number. Okay, so be aware of that. 22, this is where all of our different addenda are. So we'll check that off. We'll look at that right now in the contract. And paragraph 23, guys, this is to protect our buyers. Find out what's going on. Make sure you deliver the option fee in the 3 days. Make sure you've got a proper amount of days in there to get inspections done, check repairs, and negotiate everything. So be careful with that. And this one's critical for us. We must deliver that option fee within 3 days. This is not business days. This is different from paragraph 5. This is just days. Okay, in paragraph 23, there are no weekends or legal holidays. There is no Christmas. There is no Easter. There is no St. Patrick's Day. It's just days. And 24, guys, consult an attorney. Whoever gets the final autographs right here will execute the agreement. Broker information will be the next one. And what are we getting paid? Agency is all indicated here. We'll look at that right now. We get a receipt for the option fee now. We also get a receipt now for the earnest money and the contract with the title company. So let's take a look. Here's a list, guys, and this is on our Facebook page. This is a list of all of the contracts that I'm looking for when you write a sales agreement. All of these are included in that contract packet that I uploaded this morning. So it's the 1 to 4 family resale, the third-party finance addenda. Obviously, you don't need that if you're paying cash, or maybe you're doing owner finance. but typically 90% of our transactions need financing. Home ownership in property owner association, reservation of mineral rights. This does not affect El Paso, but we need to worry about it here in the Metroplex. The appraisal addendum, wire fraud notification, general information and notice to buyer and seller. I put the seller disclosure notice in there, guys, to remind us to get one, okay? And the lead-based paint addendum is in there for the same reason. You'll also notice that I put the numbers on the end of each of the forms. That way, when you look them up in zip forms or whatever software we might be using, you'll be able to find them right away. Okay, so basically, those are the forms that we are looking for when we're reviewing a contract. Let's click in. Let's go to an actual contract addenda. And I'll tell you what, let me come up here. I think I need to do a new share now. I sure do. And let me, shoot, which one is it? It's got to be this. No, that's desktop. No, let's go here. Okay, you should now be seeing, guys, the contract, the PDF form on the contract. And we'll just go through this real quick. Paragraph number 1, I do want to point out at the top of the page here that make sure you're using the new contract. Today is August 4th, 2018. Be aware we did get a new contract February 12th of 2018. So make sure that you've updated and you're using 2/12/18 as your contract date right now. Paragraph 1, guys, is our parties. So I think we all understand what's going on there. We're going to put the seller's name. We're going to put the buyer's name. Legal description, paragraph 2. We're going to get that from the MLS. We're going to get that from CAD. As we go down the page, you've got the improvements all listed. Please take some time and read through this sometime, okay? It talks about everything specifically that needs to be included. Someone asked you, do I need to leave the curtains and the rods? Yes, they're an accessory. You can see I highlighted it there in paragraph C. D is your exclusions. What is not conveying? Make sure that if you have something that you're putting it in that paragraph. E, this is for my DFW people. They did put in the contract, guys, that, you know what, if you want to reserve mineral rights, use an attached addendum. This is new. This was not in here before, and this is in here to cover our anatomies, make sure that we're good. And then, of course, paragraph 3 will be pretty straightforward. Down payment in A, loan amount in B, and my total sales price is going to be C. Am I doing third party? Am I doing seller financing? Might it be a loan assumption? Typically, we are going to check off the first box right there, third party financing. Disclosure is going to be done in paragraph number 4. And again, this is where I would say seller is licensed realtor in the great state of Texas. Buyer is a realtor in the great state of Texas. Seller is listing agent's son, whatever the situation might be. So if there's relationship there, you need to put that in there. Earnest money, guys, how much earnest money? Here in this blank, and the title company name and the address down here. Typically, we're putting 0 down here for additional earnest money, and this paragraph does go on and talk about the fact that the money must be delivered within 3 days. And that's on the first sentence up here, okay? Within 3 days after the effective date, you can see I highlighted it there, buyer must deliver whatever the amount is to the title company. And then down at the bottom here, guys, time is of the essence, okay? And they do talk about, again, if it falls on a weekend or legal holiday, you've got till the next day, but only that one day. Who's paying for the title policy? Again, that's negotiable. If it's seller, click here. Title company name that goes here is the same title company that we deposited money with up here, okay? So make sure you get that going. Buyer, seller initials at the bottom of each page. Top of each page should have the address. And we then got into paragraph 6. You can see the exceptions to title policy are these 8 items here. Here's what we wanted to look at. Paragraph 6A8, the standard exceptions. Well, what are the exceptions? Well, let's take a look. Look at all these exceptions. That's what you get as standard exceptions. These are things not covered by the title policy. So does your buyer want those 6 or 7 things not covered? Or do they want it, number 2 here, do they want it amended to read only shortages in area? So now we've just got 1 exception. So if that's what we want, guys, who's going to pay for it? And it's going to be probably less than $100 for this coverage. Your buyer might want to pay it. You might ask the seller to pay it. They may not even notice. Or, you know what, I'm not worried about it. Check off number 1. Okay? Just depends on the type of offer you want to put together and how everybody feels about that. It's just title company calls this survey insurance. Okay? So be aware it's there. Best protection is probably number 2. Click on seller. They may not even notice it. So anyway, now if you're a listing agent, watch for it. Okay. So anyway, Tony, well, which one do I do? Well, who do we represent and how concerned is your buyer with it? Because this is something, this is something your buyer will have coverage on in the future. Talks here about the 20 days, guys. Okay. After they get the contract to furnish the title commitment. And it does talk about down here, they might extend it up to 15 days or 3 days before closing if there's some problems, okay? Survey, number 1, if we're using an existing survey. How many days will you provide it by? And down here, who will pay for the new one? Now, this is critical. Take a look at the bold here in this paragraph. If this is kind of a trick thing that buyer's agents are doing. If the seller fails to furnish the existing survey or the affidavit, so you need to give them both within the number of days you put up there, guess what? Buyer shall obtain a new survey at seller's expense. Watch that one. So if you're a listing agent, what do you need to make sure you do? Get that survey, get that T47 affidavit ASAP. Get it within the number of days that you might have put up here. If not, it doesn't matter what you checked off down here. Seller's going to have to pay. So watch that. This is a trick paragraph. The state knows it's a little tricky. They made sure it was in bold in this part of the agreement. So something to watch there. Okay. Now, that was number 1. If you don't do number 1, number 2, buyer's paying for a new one. Number 3, seller's going to pay for a new one. So you only check one of the 3 there. Objections, guys. This long line right here, guys, right after activity is critical. You've got a buyer client. They tell you they want to run a home daycare. Make sure in here, in this blank, that big old long line after activity, you put daycare. Now, if the people move in and they find out they can't run a daycare, deed restrictions, city code, whatever it might be, the title company gets to buy their house back, not us. Because this is in the title. We told them what they were going to be doing. Some people put in here residential use. I personally think that's overkill since this is a residential contract. But it's okay. Some people put in their residential use and activity. And you can object, guys. Number 1, right underneath here, you can object the early of the closing date or so many days after the buyer receives the commitment, exception, and survey. Put about 3 days down here, maybe 5 days. If it's blank, they've got up to closing that they can quit because of objections. So put a time limit on it, especially if you're a listing agent, okay? So be aware that's objections. Notices, we talked about, there's 7 notices on this page, 8 notices now. Actually 10 notices. We do have some new notifications. Wouldn't worry too much about those. The only one I do worry about a little bit is if you're selling next to a lake in DFW, take a look at this paragraph, get with me. There's something called a water conservation district, and we've got an additional disclosure that we need to do with that. But just a couple of lakes in the area that happens with. Here's famous paragraph 7. Your seller pays for utilities to be turned on. And if you take a look at the last sentence in this paragraph, the utilities are supposed to stay on during the entire time this contract is in effect. Okay? The entire time. So don't let your sellers be cheap. And a lot of them want to turn them off right after the inspection. The appraisal still needs them. And maybe we go back and we re-verify things. They need to leave the power on till the contract is effect. Through closing, at closing, make sure buyers and sellers agents were communicating with the other party. We don't want utilities turned off. Leave them on. Okay, get the buyer to transfer utilities while they're still on. It gets crazy after the fact. All kind of problems can happen. Anyway, seller disclosure notice, guys. We really like number 1. Buyers receive the notice, end of story, period. Number 2, this one, if you haven't received it, you might put 3 days here. Now they're supposed to get it to you. If they don't get it to you, your buyer can quit up through the day of closing. If they do get it to you, they still have 7 days to review it. And they can quit for any reason. Okay, so be careful with number 2. It can turn into a free option period. Okay, number 3, estate sales. Seller disclosure notice not required. That's probably the most common one. Okay, but you guys have learned there's 11 exemptions to where you do not need the seller disclosure notice. Again, the most common one is estate sales. Paragraph C, guys, remind us about lead-based paint if we need it. The property is as is. If you read 7D, this first part right here, guys, this is where it talks about getting inspections done, doing an amendment, okay, terminating during the option period. So this is talking about your buyer's protection, okay? Check off number 1 if they accept the property as is right now. You check off number 2, they're still accepting it as is, but we might ask for a specific repair. I don't recommend putting anything in here unless that specific repair is a deal breaker. Foundation issues, maybe. You know for sure it's got some foundation issues. Maybe you know there's roofing issues. Okay? You might put that in here. Okay, maybe the hot water heater, something major. Okay, don't put replace a window. Okay, well, you could, but do all your negotiations at the inspection. Okay, but if it's a deal breaker, put it in there. Okay, and then make sure you read the bottom part here. Anything found on the inspection, you can't put that in there. You're asking for an open checkbook, and it tells you not to do it right here in this paragraph. Okay, do not insert phrases such as subject to inspections that don't give you what? Specific repairs. Anyway, E, guys, is talking about lender repairs. We don't know what they're going to be, so we can't ask for them yet. And if lender repairs are over 5% of the sales price, buyers got the right to terminate. When do repairs have to be done? Before closing. That's what's going on here. If you're worried about environmental issues, use an addenda. Service contracts, the dollar amount you put here is what a seller will pay. Okay, so be aware that that's going on here. Broker's fees, we talked about that. We've got a buyer rep and a listing agreement. We pick a closing date. Be reasonable with your closing date. Make sure you're adding in 3 or 4 days for negotiations. So don't put 30 days from today. Put 35 days from today. Okay, just something to think about. Anyway, B, what happens at closing? This talks about the general warranty deed. Sales price covers, all liens being paid. and there's going to be funds brought acceptable to the escrow agent title. When is the buyer getting possession? Is it closing and funding, or is it according to an attached temporary lease? Okay, so be aware that that's got to be filled out. If it's according to the attached temporary lease, make sure you get that filled out as well. That'll be in paragraph 22. Now, if you are using the lease, look at what they put in bold here. Your stuff isn't covered inside the house. If it's a buyer moving in early, their goods aren't covered by the homeowner insurance of the seller. If it's a seller staying after the fact, the new buyer's insurance isn't covering their stuff. So basically, what is this saying? Get renter's insurance, okay? Even if it's just for a short time period. That's basically what they're letting you know there. And then let's see, special provisions is the other one we worry about. Make sure you're careful what you put in there. 12A1B, guys, this is basically going to be a dollar amount a seller is paying for a buyer's closing cost. So be aware of that. One thing to watch here, make sure the dollar amount there is realistic. If you put too big a dollar amount, the seller's going to feel like they were cheated. Check with your loan officers on maybe the dollar amount to put in here. Okay, so get a good number from them. And the rest of the paragraph basically says who pays for what expenses. So release of liens, things of that nature are all going to be the seller expense. Buyer expense, basically what listed here, guys, any cost of getting a loan basically is a buyer responsibility. So you can look through that list there, and that's what you're looking at. Prorations, we talked about. Debit the seller, credit the buyer from beginning of the year through closing. And so that's what's in paragraph 13. 14, what happens if the property gets destroyed? Basically, the seller's got 15 days to get it back in shape. Default, one more time, enforce for specific performance, use such other relief as may be provided by law. So they're suing for damages if they're doing those two things. Or take the earnest money, everybody's done. Take the earnest money, everybody's done. Paragraph 16, let's mediate, not litigate. 17, loser pays. We talked about that. 18, title company is not a party to the contract. Okay, so you can see that there. Earnest money talks about what happens to it right here. It's going to be applied first to their down payment, any other cost. The demand paragraph, one party's not responding, you could make a written demand for the money, and the title company may, within 15 days, okay, escrow agent may disperse the earnest money to whoever made the demand. And then remember, we talked about that party who wrongfully refuses to sign. That is under the damages paragraph. So we get into that. Representations, guys, all promises survive closing. FERPTA is referred to in paragraph 20, and paragraph 21, all notices need to be what? In writing. Do not put your information here for your clients, because then we become responsible for finding them. At a minimum, guys, get an email address from them. Put their cell phone on here, okay? A lot of agents over the years say, well, I don't want these two talking to each other. Guys, they're already friends on Facebook by the time they get on contract. They're going to be driving by the house every day. They're going to meet. So don't worry too much about that. It's a much more connected world these days, okay? I remember back in the day, we had unlisted phone numbers. I don't think there's any such thing anymore. Anyway, paragraph 22, guys, what do we got going on here? The different addenda that are made a part of the contract. Check off, for instance, third-party financing, okay? Now, we go down, paragraph 23, make sure you've got an option period, make sure you've got a number of days. Typically, we're going to check off the option fee will be credited. You know what? I would probably put here in Dallas-Fort Worth, the question was how many days? 7 days. Yeah, and man, just let them know. We're getting an inspector right away. We're moving quick. You want to make it short, especially if you're competing for a property. If we've got time, maybe it's a higher end property, there's not a lot of competition, the El Paso marketplace with 5.5 months of inventory, you would put 10 days in there, okay? But I would tell you in a competitive environment, Shoot, I've had agents put in 5, okay, and just move on it. But and with a high option fee amount, $250, $300. Okay, right now my people in El Paso are choking because we're doing $25 and $50 there. Okay, again, it's all based upon the market and what the market will do. Paragraph 24, if there's any attorneys involved, you fill that out. But this clearly states that TREC rules prohibit us from giving legal advice. Okay, and again, whoever gets the final autographs, whichever agent gets the final acceptance, put in the executed date. Just about everything hinges off this date, guys. It is critical, absolutely critical. And then finally, guys, we get to the information page. Biggest mistake. Let me make this a little smaller, maybe get more of it on the screen here. This is the biggest mistake I see on sales contracts. It's an in-house sale, it's intermediary, and I will see people put the listing broker firm represents seller only, and then they put the same company name as the other broker firm. When what we should be doing on intermediary, even though it's 2 different agents, we stay over on the right-hand side of the page. The left-hand side is only used if it's 2 different companies. Make sure you're checking off. If it is 2 different companies, buyer only up here, seller only over here. If it's 1 company intermediary, we check off seller and buyer as intermediary. Okay? And so put all that information in there. Here we put how are we getting paid? Is it a percentage? Is it a flat fee amount? What is it? What does the MLS say? That'll go there. Okay, and then finally, guys, we go down to the next page. We'll get a receipt for the option fee. That'll be from the listing broker, the listing agent, the listing office. Earnest money will be receipted by title. Contract will be receipted by the title company as well. And if there's any additional earnest money later, we get that receipted. You notice the new thing is the contract receipt. They added a page to the contract because of the contract receipt. Okay, so we took care of that. Third-party financing, guys, pick your poison. Pick your poison. I think I'm going to do a class just on third-party financing. The other thing, probably the most important part of this, no matter what type of financing, is under B, buyer approval. Put here within how many days. So how many days, whatever amount of days we put in there, guys, what's going on? Well, your buyer has a financing contingency. Let's say you had 5 days on the option period. I would put 5 days in here. Make it 1 date, okay? Now, what's happening? If I put 5 days in there, my buyer can quit if they don't get qualified during those first 5 days. Now, again, it depends on your marketplace. If you're in another market, you might put 21 days in here. That might work in El Paso. I would tell you this. People ask me all the time, well, Tony, how many days would I put in there? And my question is always this. Answer a question with a question, who are we representing? If it's a buyer, you want more days. If it's a seller, you probably want less days. Either way, the agents need to keep track of this and advise their clients and be in constant communication with who? The lender. Let's say we got 14 days and they find out on the 15th day that they're not qualified. There's no finance contingent. They're probably going to lose their earnest money. And we're out of option period too. So be careful with the number of days. Don't leave it blank either. What happens if you leave it blank? Infinity? Up to closing. So make sure you do not leave that blank, okay? We'll get into a debate on that sometime. But how do we get finance approval? Well, number 1, we need the buyer approved. And don't forget about paragraph 2, the property's got to be approved. It must meet the lender's underwriting requirements, appraisal, condition, title, survey, all of those things have to be approved. So that's your third-party finance. The next form I included, guys, if you're in a property owner association.
Hey, Tony, I have a quick question.
Yeah, go for it.
So yesterday on the night, I went to put an offer for a property. This is the first time it happens to me. This lady was a little special cookie. Let me put it that way. So, sorry. And
The
the
listing
special.
agent you're talking about?
So I have the buyer. I put in an offer for actually one of those short sales that we have in-house. So my client, this lady, she wanted to put in special provisions on the contract that the offer might terminate it onto a specific date. I explained to her like, look, you can get out of the offer if they don't, by the time they haven't answered us back, we can we can take back the
Respin?
offer.
Right.
Uh-huh. But she said, something, I'm not signing anything if I cannot have that on the special provisions. So what I said, something, you have to write it. I cannot write it because I'm not a lawyer. And I don't want to write like a lawyer. But I was going to ask you, is that possible to do on the
It
special
is.
provisions?
It is okay to write that in there. Now, this is. Let me give you the difference between being an attorney and just putting in a factual statement. We're
Okay.
talking about paragraph 11 and putting a date in there when the offer is no longer in effect. So this is okay.
Okay.
This offer expires on August 10th at 5 p.m.
Okay.
Real simple. This offer expires at 5 p.m. on August 10th, 2018. Now, this is illegal. Time is of the essence, comma. This offer expires at 5 p.m. on August 10th, 2018. That time is of the essence is a legal term. It is a complex legal concept. We cannot put in time is of the essence. But it's okay to say, hey, this offer expires 5 p.m. on August 10th, 2018. We see it all the time. We do see that one all the time, Enrique. I appreciate you being very careful with that, but that is okay to put in our sales contracts.
Yeah, because usually if I have a client that want to submit an offer and they want to put something in special provision, I prefer if the principal is the one that's going to write it instead of myself, just, making sure
Yeah.
that I
And
know.
there's nothing wrong with that, but that particular phrase, nothing wrong with us putting it in. Do not use time is of the essence, and we're fine.
Okay.
Okay. And then your other thought, I do really like your other thought as well, Enrique. When can you rescind an offer? At any time before they tell you it's been accepted, before acceptance and notification. So if Monday afternoon rolls around, we didn't put that phrase in there, and your buyer says, man, have we heard anything? No, man, we haven't heard a word. Says, you know what? Rescind my offer immediately. We send an email to the listing agent, and all it says is this: effective immediately, the offer on 123 Anywhere Street in Anywhere, Texas is rescinded. You can do that immediately. You can do that anytime before you've been notified by the other party that exactly. So you're good to go. You're good to go. So, but you're absolutely right on that, Enrique. Absolutely right. Okay.
All right,
Now,
Danny.
let me go through a couple of these addenda. I'm going to do a separate class just on addenda, so I'm going to gloss over these. But if you've got a homeowner association, the homeowner association name and phone number will be in the MLS. So that's what you would put here in the second line. Okay. It talks about name of property owner association and the phone number. So that would be there. And then there's subdivision information that we need to get from title. So who's going to pay for it? Okay. And within how many days? The first blank is seller will pay for it. The second one is buyer will pay for it. 3 is we've already received it. Maybe the seller's already got it. Maybe it was in the MLS. And then number 4, buyer does not require delivery of that information. Okay, maybe they don't care. But make sure that we're getting this one filled out. And title company is only going to order the info when they've received payment for it. So if someone wants the info, it will have to be paid for before. Okay, and then there's transfer fees, guys. Put a dollar amount in here that the seller will pay. Probably looking between 150, 250 bucks. Okay, so typically a seller would pay that. And again, who's paying for this information is also down here under E. So we would fill this out with the contract if we're in an HOA. Okay. Oil and gas reservations. This one we use in DFW, not required in El Paso. So are they reserving or are they not reserving? Okay, all, or is it an interest? And again, funny words in here is we're reserving it, if any. Okay, we've done a lot of training on this. We know the title company doesn't cover it. It would have to hire a landman if they're worried about that. So that's what you got going on there. If the appraisal addendum, guys, I'm going to do a whole class on this. There's 3 different issues here. And number 1 is, you know what? I don't care what the price came in at, the appraisal, I'm paying you the sales price. So your appraisal might have come in at 90,000 and we had a sales price at 100,000, you're paying the 10 grand cash. So letter A, number 1, is for your buyer that's got money. Now, one other quick thought. Look at this phrase right here. You cannot use this addenda with FHA or VA. Just conventional. Just conventional. Number 2, we put a dollar amount here. This gives me a little bit more protection. Maybe I put 105,000 and I'm at the sales price of 100. I'll only pay you 5 over. Okay. And then down here, you can say, you know what? You may pick a different dollar amount, but it's like lease protection, a little bit better, most protection. And I'll do a separate class on that. This is something we see a lot more of in DFW. Wire fraud, guys, I want to make sure everybody's familiar with wire fraud. Have them sign off on that. And lead-based paint, this is just a reminder in case you need it. And the next one is general notice, information and notice. And basically, again, I'll go through this when I do addenda, but I guarantee you guys, every paragraph in here, there has been a broker that has been sued on it over the years. So this is kind of a cover your anatomy form. And I'll talk more in detail about that particular form and let you know what's going on there. And again, I'll do a separate class on that. Seller disclosure, this is also in here just to remind you to get it. Okay, so we'll get that from the seller. And then the following page, I think that might be the last form. Yep, that's the last form. Let me go back here. I'm going to stop that share. And I should be back on track with you here. Oh, we got an iPhone here with us. I'm not sure who, I can't see a number. But guys, that is basically the contracts training. So I'm going to, this has been recorded, so I'm going to go ahead and post this to the Facebook page. I've also started a YouTube channel. I'll probably update this and put this on that page. But let me do something here. I do want to end the recording. Well, I'll end it now. Basically, guys, this is contracts, the resale contracts training. And shoot, we were on here for about an hour and 12 minutes or so. But I'm going to go ahead and stop.